Good morning. This is Paul Nall from Precise with episode 2 of Paul's Pondcast. I am joined today with Sud Patel from Finelli, Evans & Patel. Good morning, Sud.
Good morning, Paul. How are you?
Fantastic. Yourself?
Doing great, thanks.
Why don't you give us a little intro on who you are and then your background as a trial lawyer?
I've been a trial lawyer for 25 years now. Every year that I've been doing this has been in one firm, Finelli, Evans & Patel. We're based in Pottsville. We're about an hour and 45 minutes northwest of Philadelphia and about an hour from Harrisburg and Allentown. The majority of my practice is personal injury, car accident cases, as well as medical malpractice cases. I still do a fair amount of criminal defense work, a little bit of construction litigation, and because we're in a small town like Pottsville, we still do a lot of municipal solicitorship work. I'm a solicitor for a local school district and special counsel for several others. So it's a pretty broad practice, but I would say the majority focuses on representing injured victims.
You had mentioned you're there in Pottsville. Is it something, how does the breakout for your practice where the cases are venued?
Sure. We've got a lot of cases in Schuylkill County, but we also see the surrounding counties, Carbon, Berks, Luzerne, Lackawanna, Lebanon. We've got cases in Dauphin County. We file cases in Philadelphia as well. And the construction litigation part of my practice has me going to the western part of the state as well as some other states from time to time.
And it's also something where you are the current president for the Pennsylvania Association for Justice?
I am. I'm the current president of Pennsylvania Association for Justice, formerly PATLA, the Pennsylvania Trial Lawyers. I've been a board member there for about 15 plus years and became the president this past July. It's a one-year term, and that's been a lot of work and a lot of interesting issues along the way as well.
What's something you've been, I guess, most proud of so far halfway into your term?
Well, as any president of PAJ or a trial organization will tell you, the thing to be most proud of is nothing bad has happened under my watch the first 6 months. And, my wish list for the next 6 months is the same, that we don't have any terrible tort reform legislation passed. But it's been a real great experience, Paul. I've literally covered every corner of the state and a lot of trips to Harrisburg, a lot of legislative, political functions, and really getting involved with the day-to-day operations of what we do. Again, I've been really proud of the fact that we've developed a great relationship with our regional trial lawyer associations, our colleagues in Philadelphia, northeastern Pennsylvania, the central part of the state, and also the west. So it's just been a real rewarding experience being president of, I would say, probably one of the leading trial lawyer associations in the country at this point.
Absolutely. Congrats again on that. Other than keeping from anything bad happening with tort reform, what's your biggest goal for the remaining of your term here?
Well, the biggest goal is we're really trying to get the mandatory minimum limits for automobile insurance coverage in Pennsylvania increased. We are embarrassingly the 49th lowest state in the country in terms of mandatory minimum limits. That is a huge priority. We're also literally waiting any day now for a report to be released from the legislature outlining whether or not there's been any market impact from 2003 med-mal tort reform measures focused on venue. So we expect a report to be released, and we've been doing a lot to try to get the venue rules rolled back to the way they were pre-2003, which would be a significant step for us. Obviously, with 2020 being a huge election cycle, not only statewide, but with the president's race in play, we are focused laser-like on fundraising and marking key races where we think we can help some candidates get across the finish line. So that's really going to be a big focus of what we do. And then beyond that, just the day-to-day running of the organization, making sure that our list servers are there, making sure that our business partners are continuing their relationships as Precise has done for a long time, and we appreciate that. And just making sure that we continue our efforts with member services. I mean, we're over 2,000 members statewide, and we're one of the few trial lawyers that hasn't seen membership attrition. So, that is literally a week in, week out process of making sure that we continue to give our members value for their membership.
Certainly. And I guess as far as for those that aren't aware, the tort reform, and is that was that specifically for med malpractices where it's making the case filed where the alleged negligence happened as opposed to just wherever that hospital holds business or has business?
Sure, that's exactly right. So pre-2003, you could file your lawsuit anywhere where a defendant could be served. That refers to the venue. In 2003, under the guise of medical malpractice crisis, the legislature, along with the Supreme Court, changed the venue rules so that you could only file a medical malpractice case in the county where the malpractice happened. Fast forward from 2003 to now, you've got these mega hospital networks now that are literally taking over the world as it relates to not only medical practices, but hospital facilities. We see UPMC, University of Pittsburgh Medical Center, coming to eastern Pennsylvania, to Lebanon County and surroundings. We've got Geisinger, the Reading Tower Health Network. So these mega corporations are not only buying up individual doctor practices, but also hospitals. Our argument is, look, we should be able to file the suit wherever we can get service on a defendant. No different than if you're suing a lawyer for legal malpractice, an architect for architectural malpractice, or any other professional.
Or any corporation for any
corporation, exactly.
And as far as the limits in Pennsylvania, it's currently 15. Is that the minimum?
It's currently 15. We'd like to see that get raised to 25. So to 1530, 2550, along with an increase in medical coverage as well.
Sure.
So it's something that really should happen. Everyone thinks that is solely a trial lawyer issue, raising mandatory minimum auto limits. It's not really. When you think about orthopedic surgeons and hospital networks that are providing care for people injured in car accidents, they stand to benefit if mandatory insurance coverages are available, especially medical benefits and liability coverage as well, because then the state ends up picking up the tab for a lot of medical expenses that are not otherwise covered by third-party insurance or first-party insurance.
Well, best of luck with that.
Thank you.
So, just touching a little bit on your career. So when was it you determined that you wanted to become a lawyer?
Well, it was an interesting path. So if we wind the clock back, Paul, to around 1986 or so, my dad was a partner in an engineering firm here in Schuylkill County. He and his partner got into some major disputes, and my partner tried to squeeze my dad out of the business and actually tried to literally fire him. It was at that point that my dad came to my mentor, Fred Finelli, and deceased partner, Jim Riley, and they represented my dad. And I wasn't the type of kid that was allowed to vacation at the Jersey Shore. I had to work during the summers, and my dad would drag me along to his meetings with his lawyers and to a lot of the hearings, and I really became interested in what lawyers do and saw firsthand through my family's own experience how trial lawyers can help put pieces back together.
Sure.
My dad was faced with a situation where his entire life's work, covering 2 continents and all the savings he had, was really going to be wiped out if his partner had his way. And through the efforts of the guys that then became my law partners and mentors, we were able to save everything my dad had worked for. So it was at that point, 1986, 1987, and even into my high school graduation, that I thought being a trial lawyer was something that would be really interesting. Ironically, my dad coming to this firm and being represented by them paved the way for me to get some summer internships, and I spent my holidays, Christmas breaks in college at the firm, and eventually I pretty much forced them into giving me a job, and it's been the only grown-up job I've held. So, my connections to my current firm trace back to around 1986.
Right, just that impact that it had on your family.
It did, yeah, and certainly through PAJ and also just 25 years of practicing as a trial lawyer in all kinds of cases, personal injury, transactional cases, you really see that trial lawyers do an incredible amount of good work. And, I always use the term, we help put pieces back together in people's lives. And that's absolutely true. It's been a great 25 years, a great profession. I can't think of anything else that I'd rather be doing.
Great. That's great. So seeing how how those attorneys had the impact on your family, what's something as you look back over your career, what accomplishment or impact or difference that you made is one of the crown jewels that you're most proud of?
Paul, that's a tough question. There's so many, and I could literally take hours answering that question. But, some of the things that I'm most proud of is being able to do the high quality work that we do at our firm with my partners here in Schuylkill County. I'm one of the few lawyers, I think, across the state that can actually say that he has not only had million and multi-million-dollar jury verdicts, but also acquittals in first-degree and felony criminal cases as well. I enjoy being in the courtroom, and I'm just really proud of a lot of the success that I've had, my partners have had, and I try not to get too complacent. There's always more to learn, and there's always a better way to do it. And what I'm really passionate about, that I preach to my younger partners and associates, is, you've got to find the latest techniques and trends in trying cases. And, I go to a lot of continuing education courses, and, I've never been one to let my ego get in the way of being better. I think there's always something that I can learn, someone that I can learn from. And really, if I look at, I think the level of work that I've done and that my firm's done, it just gets better and better every year. And I'm really proud of that. Beyond that, I would say that just being able to give back, and that's something that I'm very passionate about, whether it's coaching youth sports or speaking. I do a lot of speaking engagements on distracted driving, most recently social media misuse, letting kids know the kind of trouble that I'm seeing kids get into. And so I spend a lot of time giving back with my time and my effort. I'm a Little League baseball umpire and coach basketball, and put on clinics, and we do a lot. There are a lot of things that we do that we try to fly under the radar. If a family's had a devastating fire, just making sure that we help them out a little bit financially to get back on their feet. And again, I'm passionate about schools and kids and mentoring, and so I've just been able to have a wonderful life, both professionally, financially, and just in terms of giving back. It's been a great run so far.
Pillar the community for sure. So what's more stressful, being an umpire in a Little League with the parents yelling at you, or being standing in front of a judge and jury?
Without a doubt, umpiring behind the plate at Little League games, and being the president of the Little League, which I had for a number of years, and also the president of a current youth basketball league, I would say is a lot more stressful in some ways. I mean, look, the reality of it is, and those are all recreational activities, and you get unruly parents, but that comes and goes. But now the real stress, candidly, is aside from raising kids, I would have to say, because I've got two of my own, 14 and 12, two boys. But the real stress comes when somebody's entrusted you to put their pieces back together. And, that's a lot of responsibility, no matter what type of case or what size of case, putting it on the line, going in front of a jury, trying to make sure that you do everything you can to convey the harms, injuries, and losses that your client or clients have suffered. And knowing that sometimes you're going to be rejected. I mean, there's not any of us who do this line of work that hasn't gotten a verdict that's been a defense verdict, or a verdict that's been not nearly significant enough for what your clients have lost. That's a lot of stress and responsibility.
Absolutely. So as you were talking about this, as far as improving your practice and the way you try cases over your career, what would you say kind of some of the biggest evolution, or how you've adapted your practice over the years to be a better trial lawyer?
Well, I think technology has had a huge impact on the practice of law as it relates to trial lawyers. I mean, there are literally some trial lawyers that try their entire case from an iPad, which is amazing. I don't have that level of technology yet, but Paul, in a short amount of time, we've gone from poster boards or looking at pieces of paper and circling or highlighting to now having presentations like you do for us at Precise, using Trial Director, having a big screen or multiple screens, animations, settlement videos. So there's been a lot of evolution technology-wise. On the non-technology side, the theory of how to try cases and strategies is constantly evolving, and it depends on what the generation of jurors is like. The Generation X or Generation Y jury, you've got to try your case much differently than you would have, 15, 20 years ago. What do jurors expect? Different strategies. So there's a lot of competing thoughts on it, and I think a lot of it you have to be adaptable. I'm not going to try a case in Philadelphia the same way I'm going to try a case in Schuylkill County. I'm not going to try a case in Schuylkill County the same way that I'm going to try a case in Snyder County or Columbia County. And that goes on all ends in terms of the presentation, the arguments that you make, how you try to convey your client's losses, right down to the technology. Sometimes, with all due respect to what you and similar companies do, too much technology can turn off a jury. You've got to really make sure that you have the substance of your case nailed down first.
Sure. So is it something where you'll forego technology in a courtroom presentation completely in a much more rural county than elsewhere?
I think, Paul, it's a function of the type of case you have. Okay, I mean, if we're going to be honest here, not every case is a potential $1 million or $2 or $3 or $10 million case, and I think you have to fit your entire presentation around the parameters of a case. If you've got someone that you're taking to trial that has had limited medical treatment, and the medical records are, maybe a quarter inch or a half inch thick at most, it may not make a whole lot of sense to get into animations, and you're certainly not going to worry about day in the life videos. Depending on the makeup of your jury, I have tried cases where I've just used paper and I haven't used the screen and I haven't used trial director or had Precise come in and do the presentation for me. Having said that, on the other hand, depending if it's a younger jury that may be more expectant of technology in the courtroom, you have to make that adjustment. And so I don't think there's a clear-cut answer to it. I think you have to be adaptable in how you present your case and the level of technology that you use in the case.
Sure.
Also, the extent to which you do. I mean, if you have a clear liability rear-end case and the medical records are pretty straightforward, you're not going to go and get an animation done if the other side is admitting liability. You can overdo it, and I think ultimately we've all got an obligation to our client, and a case that may have value of $50,000, you're not gonna spend $25,000 in cost to get there. So every case is different, and I think the good trial lawyers, of which we've got a lot in our association, and I practice with several of them here in my firm, we know that you've got to look at each case differently and be adaptable.
Find that cost-effective analysis.
Exactly.
Analysis to be able
Yeah.
to,
But
so
I'll
I
tell you,
guess that-
Paul, one thing that if I can touch on, and we've done this recently with your company twice, is video settlement packages or settlement videos. And I have found that in the right case, they're incredibly, incredibly effective and incredibly helpful. For a number of reasons. I mean, first, despite what anyone may say or what anyone thinks, the insurance companies keep track, and they know the lawyers and law firms that are not afraid to go to court. They know the lawyers and the firms that are willing to work up cases the right way, and they're going to make offers and they're going to set their reserves and give their attorneys, their defense lawyers, authority based not only on the merits of the case, but on who's on the other side of the case. And when you get to a rural county like Schuylkill County or the surrounding counties that we practice in, I think it is critical that you take your significant cases and work them up the right way. And we found settlement videos to be very effective doing that. Now, our colleagues on the defense side will say, we don't really worry about settlement videos, and we know the value of cases, and you're wasting your time. I disagree with that. I think that, that's a little bit of gamesmanship on their part. But the settlement video does, in my opinion, a couple of things. Again, it definitely conveys to your opposition and the adjusters on the other side that you're willing to work the case up the right way, and you're willing to put the time in and the expense in order to work the case up. The other thing that I find very helpful is it really gives you a good window into your potential trial witnesses when you think about a settlement video early on. You have an idea of what these folks will present like that you can get on video that you might not get over the phone or even in a meeting in the office. So that's another benefit. Also, it makes you really focus early on in your case about what are the recoverable elements of damages. The great teachers and the great mentors that we all have and the more seasoned trial lawyers will always tell you that as soon as that client walks in the office and you get the facts, you should be thinking about what are my jury instructions going to be? What are the elements of damages that I'm going to be entitled to ask for and potentially recover in this case? And to my experience, thinking about and putting together settlement videos helps me focus early on the recoverable elements of damages. The other thing it does is it just gives your client and your witnesses a comfort level early on. And again, we've done two very recently with Precise, and I think it was absolutely 100% the right decision to make in the two cases we did most recently.
For those cases, you said you start thinking about the jury's instructions early on. As far as what point in the case are you considering doing the settlement video? Obviously, you have to have a mediation lined up, but at what point are you talking about mediation and preparing a video project like we've done with you?
In the two that we've done recently, pretty early on, and I'll be honest with you, the one I did with Jamie Muth from your office, I started the settlement video thought process and the planning before there was ever an agreement to mediate the case early on. It was a good liability case. It was a strong damages case. It certainly was a multi-seven-figure dollar case. And I just made up my mind that I want to put the settlement video together. And that video was going to be sent regardless of whether we ended up agreeing to mediation, which we did. Mediation wasn't successful in settling the case. We settled the case on New Year's Eve. But I think the settlement video in that case was invaluable, and I thought about it early. And much like the second one that my partner Al Evans is working on with you currently and with Jamie, it was the same thing. So I think in the substantial cases, you should be thinking about a settlement video early on, even if that video is never given to defense counsel. And even if the mediation process is stalled or it doesn't happen until after the depositions are finished, I just think it's an invaluable tool to get you focused on your case and to start the process moving along.
And I guess it's something where for the one that we had done with you recently, that was a bit of a different approach than we've done in the past. As you said, it's always evolving and getting better. But an idea you came up with was wanting to take a town hall approach with coworkers and friends. What was your thought process behind that?
I just wanted to do something differently. I've seen a lot of settlement videos. In fact, we've done them in the past where we have the camera focused on one person and we, ask the questions and have the potential witness or the client talk about their observations of, our client or the decedent, the person that passed away. And it's just one person on camera at a time. And they can be very, very effective. And certainly I'm not arguing against doing that. But for the case that we did that wrapped up at the end of last year, I just wanted to try something different. And I wanted to just see what would people say. And really, I just, looked at some other interviews or political town halls or political debates and thought, what, let's just see how it works. So it was a new one for me because I had not done a town hall setting before. And what we did was we had a lot of people. So I didn't want to have 8 people in chairs and have the camera not be able to focus in and make Jamie's life tough. So what we did was we did 2 groups of 4 and we had them seated, next to each other, very close together. And it was really neat watching the interplay between the witnesses that we had on camera who knew each other very well. They were all from the same neighborhood, but they brought different perspectives into my client who died tragically in a car crash here in Schuylkill County. And it was just really neat to watch the interplay. So it's definitely an approach that I plan on using again and again. But again, you have to have the right group of people that you're putting on video. To have a town hall approach where you have 2 or 3 people on the camera at the same time who don't really know each other and aren't comfortable with each other, it could really backfire and not be effective. But in the case we had, these folks were very, very close. They all belonged to the same fire company. They went out to dinner regularly. The husbands and wives spent a lot of time together. The kids were all friendly within the families. And I thought it was just a great way to approach it.
Yeah, and I think the final product in that came out very, very compelling and very powerful, for sure.
It really was. But, just on the issue of settlement videos, I think, there are a lot of things that you should be thinking about when you're going to put this together. Obviously, listen to your videographer and let them handle the technical part of it, the room setup, the camera angles, the chair spacing, all of that. But I think you can't just look at your client and potential witnesses and say, meet me on X and such a date at this place, we're going to do a video. I think you got to do the work early on. You've got to explain to them, what is the purpose of the video? Why are we doing it? So they're comfortable with it. I mean, I had 2 people in the video that we had just done recently that I could tell were really, really not comfortable being on camera, and we excluded them. So you have to let your client and your potential witnesses know, why are you doing it? You've got to give them a sense of what are you going to be asking? And you've got to explain why you're asking those specific questions. I mean, everybody wants to come in and talk about what a great guy John was or what a great lady Jane was, but in the context of what is admissible at trial and what you're going to be able to present to a jury, folks that are not familiar with what we do in litigation might not understand the importance of asking specific questions. So I think you got to have the witnesses and your client prepared. Another thing is you've got to take care of the little details. How do you want them dressed? What are they comfortable in? No different than preparing for a deposition. And then you've got to give a lot of thought as to the sequencing of the questions, because otherwise you're going to get a final product that looks so heavily edited. So you have to think about the flow of the questions. Now, understand you've got to be flexible. A witness may start out talking about one thing and just give you some great insights on another area, but I think you've got to do your work early on. It can't be as simple as show up and we're going to do a video and talk about what a great guy John was or what a great lady Jane was. That's you're selling yourself short, and you're really doing your client a disservice.
And I think that was also unusual in that particular project as well, is that your actual clients weren't in the video at all. The family members, the widow, the child was not included in the video.
It was a conscious decision on my part because, the emotion was so raw for my client who had just lost her husband and my 20-year-old son who had just lost his dad, that they were not going to be able to keep it together on the video. They could not keep it together when I was in their dining room at their home talking to them. And I knew the video was just going to be tough. And, I had to make a decision. They are still going through a lot. And to put them on video might have been really devastating for them. Now, they were present and they were in the room when we shot the video with the two groups in the town hall setting. And that was tough for them. But it was a strategic decision on my part. Remember, you always have the ability to supplement the video later on when things progress a little bit in the case. So I wasn't concerned at that point not having my client on video. The one we most recently did with you, different story. We had the client, again, tragically lost her husband when a construction company that was in charge of traffic safety made an illegal U-turn in front of him when he was riding his motorcycle home from work. But in that case, we had his surviving widow and his two grown daughters on the video, and they're going to be part of the settlement video that we put together.
Right. So definitely a case-by-case basis, who you're asking to participate and what the final product will look like.
But, let's just talk about that for a second, because in my opinion, the video can and should be much more than just having some faces talk about the damages or the losses. For instance, in the videos we've done with you, we have the local news station footage that we have edited into the video. Family photographs played the client's favorite song. We have grabs from websites that we've blown up. We've had medical animations and illustrations. We've had excerpts from preliminary expert reports that have been blown up and actually read by a third person. So you can get very creative. A Google Earth shot to orient whoever is going to watch the video as to where the crash happened, what the intersection looked like. So you should be thinking about more, in my opinion, than just having some faces on the camera and having them answer the questions that you plan on posing to them. You can get really creative. And I've seen, again, some of our colleagues' settlement videos, and really the sky's the limit in terms of creativity and what you can put in.
And I guess for that particular case, you did start it off with the news footage, which the anchorman specifically said that your client was killed on impact.
And that was, we did. So, of course, we had witnesses and our investigators went out and found that that was not the case. So, we had to talk about that in the settlement video, and we had excerpts, and we had the board-certified forensic pathologist give us a preliminary opinion, having reviewed the interviews and the medical records and the coroner records, and we had to address that. But, I wasn't certainly going to edit out a portion of the news footage because I think you lose credibility. The footage was what it was. And again, that footage came on the night of the crash. So I wasn't concerned about it.
Got it. And I think we did take the approach where you showed the 30-minute or 30-second clip and immediately right off the bat started talking about the 8 minutes of pain and suffering and getting into the autopsy report. And right. Curious, did you get any feedback, or have you gotten feedback from, I know you said earlier, defense counsel usually say it's a waste of money and time, but have you ever gotten feedback from insurance adjusters after the fact, if it resonated with them?
Sure. I've had it both ways, Paul. I've had some more, what I'll call more seasoned and experienced insurance adjusters play it pretty tight-lipped and not comment on it at all. I've asked, following a mediation, what'd you think of the video? And they kind of just shrugged it off. And then I've had some others that I think have been a lot more candid that said, look, you've got really good people. Certainly this was a case we knew we didn't want to try. You did a really good job on the video. So I've heard it both ways. Understand, with what we do, it's tough for defense counsel to tip their hat to us. But right. I certainly stand behind the proposition that there's really no downside to a settlement video. And I think it's a great way to focus in early on in cases, especially cases that are substantial.
Sure. Has there ever been a request, if it's something where they ask for, and since it's for mediation, I guess that would be different on the rules of evidence, but if it's something where kind of the edited cut out footage would be, they would ask for if it's something where it could be producible.
Well, in the context of day in the life videos, which I know, Precise does a lot of them, we've seen those requests being made that, look, we want all the raw footage. We want the unedited footage, not just the portion that is here. And, we fought that fight and we've been successful saying, look, this is a day in the life video and it is what it is. I haven't seen that litigated up through the appellate court. Certainly we haven't had that experience.
Okay. But it's been your experience that they only get kind of the final edited version of the day in the life as opposed to the 8 hours of raw footage that might be there.
Sure. And that's certainly our practice. Hopefully our opponents don't spend a lot of time looking at this section of the podcast and start making those requests. But now I think they're entitled to the final product. It's a day in the life video.
Right.
You always have the ability to say, all right, if you want it all, then play it all. And let the onus be on them to sit there and bore the jury with 8 hours worth of footage.
Okay. What's your approach as far as when you do provide the final video for mediation purposes? Do you send it to them in advance of the mediation, or is it the premiere is actually at the mediation when everybody's in the same room?
I've done it both ways, and I'm more inclined now to send it in advance. Okay, I had a mediation a number of years ago, again, fatal crash case involving a truck. It was a trucking case, and I played it for the first time at the mediation, and it didn't have as much impact because, we got into, well, why wasn't this given to us? And it would have been nice to have this ahead of time. So my feeling is, if you're going to do a settlement video and you want it in order to help drive a successful mediation, once it's finally edited and you're happy with it, get it to defense counsel and get it to the adjuster and let them look at it at least a week to 10 days in advance. That's the approach that I've taken, and I think it really makes a whole lot more sense than trying to spring it on somebody at the mediation. Because remember, a lot of the decision making on the defense side with defense counsel and the adjuster, and if necessary, the adjuster's settlement committee, the supervisor, whoever sets the authority, those discussions are not going to happen the morning of your mediation. They happen in advance. So I think the sooner you get the settlement video to them so that they can analyze it and make any adjustments to the amount of authority they're going to give their counsel or the amount of reserves that they need to set or anything else, sooner is better, in my opinion.
Okay.
But, one other point on that, Paul, I think in order to have effective settlement videos, we all get wrapped up in our cases and we all think that we've got a great case and we're going to do a great job. But one thing that I did with the settlement video is I had my partners and also my wife and my paralegal take a look at it before we said, okay, it's in final form and we're going to send it out. And there are some tweaks that we made prior to the final version based on the input of others. So if you're fortunate enough to not be a solo practitioner, if you've got staff or, let someone else take a look at it. And I know within PAJ, we're happy to help our colleagues on anything and everything. So I think you have to get some outside input because something that you might think is fantastic in the way of sequencing, you might show it to someone that's not as connected with the case who's objectively going to say, why are you starting with that? Or, geez, I don't really know why you put that in there. I'm not really sure what you're trying to get at. So, it's a creative process all the way through. And I know, with Jamie, who really spent a lot of time from your company helping me with the video that I did, I sought a lot of input from her. So I think you have to really be willing to accept all kinds of commentary and constructive criticism before you get it to a final product.
At the mediation, do you tend to let the video speak for itself? I know for that one we did, it was narrated, so it certainly had its own standalone value, but do you tend to play the video and then provide any supplemental narration or advocating for your position? What's your approach?
My approach has been to not play settlement videos. In addition to getting the video, the final product, to defense counsel with an extra copy for the adjuster, I also send it to the mediator. At the same time, I give it to defense counsel. I want the mediator to see it and see it in advance. The reason for that is severalfold. First of all, I think sometimes playing a video can distract the entire mediation process. I mean, think about it. Your client, in all likelihood, this is his or her first and only mediation that they're ever going to come to. They're nervous. It's uncharted waters for them. You've got a lot on your mind in terms of how is this going to go? What am I going to say? different mediators handle cases different ways. I'm seeing more and more mediators getting away from what we used to call the dog and pony show, where you get everyone in the room and then the mediator gives plaintiff's counsel to talk about what a great case they have. And then they give defense counsel a chance in front of your client to talk about all the holes in your case. More mediators are just bringing it together, explaining the process, doing the introductions, and then separating the parties. So to play a video might not necessarily advance the ball. And what it might do is just take up time. And then you've got to worry about your client's frame of mind seeing that video again.
Sure.
So we get it to the mediator in advance. Now we have it at the mediation. We say, look, we're happy to play it again if anyone thinks they haven't seen it or you need to. And most often the mediator will say, I'll take a look at it. And they've taken notes and they know what the video entails.
Which certainly gets back to having that early approach to getting it done, even if there's not a mediation scheduled. Sometimes they can pop up pretty quick on you. So if you've already started the process, you have it finalized and still able to get it to them a week or two in advance of the scheduled mediation.
Yeah, I keep saying, what's the downside? Okay, because look, once the interrogatories start being served on you, they're going to want to know the witnesses that you're going to call. You're going to have to disclose the witnesses that you're going to call in advance of trial. You might as well let the defense see what your witnesses are like and what they have to say. It may discourage them from taking depositions, especially if you've got really good people, which we've had in the two cases we've done these videos most recently with Precise. These people are just fantastic people. There's not a single trial lawyer that wouldn't love the opportunity to represent our clients and work with these particular witnesses. So put it out there. I just don't see the downside. There's no point in playing hide the ball, because on the substantial cases, you're going to be dealing with experienced defense counsel. They're going to want to know who are the witnesses. They're going to depose the witnesses. They're going to have investigators out there. So I don't think you're tipping your hand or giving anything away by putting together settlement videos in the appropriate case. We've talked about witnesses that you're going to present in the settlement video, but I think you got to give a lot of thought to who those witnesses are. A settlement video that has the same type of people that are connected to your client saying the same things loses effectiveness. So, do you have somebody that was a coworker of your client, a next door neighbor, a family member, someone that they grew up with that they've stayed in touch with, somebody that they coach with? So try to get people from different walks of life that can give different perspectives on your client. And I think that adds to the effectiveness of the presentation as well. Because again, to have, okay, we're going to have two coworkers and they both work the same shift with your client and they do the same thing as your client and they're going to talk about what a great worker he is over and over and over again. I think you leave a lot of meat on the bone by taking that approach. So I think you have to give a lot of thought into having a diverse group of people on your settlement video that can talk about different perspectives.
Really give kind of that 3D picture of who that person was.
Sure. And also, depending on your case, look, we've all had them. We've had great liability cases with damages that, for whatever reason, we've got issues. We've had great damages cases, but the liability's tough. So I think as part of the settlement video, you also have to remember you're focusing and you're going to try your case on liability and damages a lot of times, the cases that go to trial. So you've got to think about in the settlement video, who are your witnesses for liability going to be? Who are your witnesses for damages going to be? Is a settlement video going to be a damages only video? Is it going to be a liability only video? Are you going to present one video for liability and then maybe later on think about the damages video? Again, what's the percentage between liability and damages? Those are all thoughts that you have to give consideration to.
Well, that's kind of all the questions I had. Sud, is there anything else you'd like to share with our viewers here?
No, getting back, Paul, to the initial point that I made, when you're doing a settlement video, again, obviously it can really help you get good cases settled. But I think it also helps your gravitas as a trial lawyer because it sends a message to the defense bar. It sends a message to the insurance adjusters that, all right, I'm dealing with a lawyer that has his act together or her act together. They're willing to work up the case the right way. When you're in a county like Schuylkill and you're trying cases in Lebanon County, Carbon County, Schuylkill County, more rural counties, I think it just really helps you in the big picture. Maybe you don't get the number that you really want in that particular case with your settlement video, but I think the trickle-down effect or the long view of the world is something you have to keep in the back of your mind. It really can help you. And the other thing, too, is, if you're going to do it right, okay? Get a company like Precise, partner up with Precise, and get it done the right way. The quality of what you and Jamie have been able to do is something that we just couldn't replicate if we had somebody that just dabbles in, settlement videos or videography. So that's another important point. Also, Paul, beyond just a settlement video, I'm of the school of thought that if you have a case that you think you're going to have to try, video all the depositions. Okay, take them all, because there are certain mannerisms and certain expressions that come up on video in a deposition that you're not going to get just by reading a cold transcript. And I think that's important. Number two, if you're in a case with difficult defense counsel, someone that objects and has speaking objections and is really a pain in the backside, I have found that videotaping depositions with difficult opponents on the other side keeps them in check. It keeps them honest.
Okay.
The other thing, too, that a lot of people don't realize is certainly in jurisdictions, I would say more closer to Philly and Pittsburgh, judges allow you to play video clips from depositions in part of your opening. Now, there's some counties that say, nope, you're not allowed to show any exhibits, play anything, but that can be a gold mine to help drive value in your case and help, cement liability or solidify damages doing that. Again, if it's a case that you think you're going to try, I would encourage all of my colleagues, consider videotaping all of your depositions. There's really a lot of upside to doing that.
And it really gives you, by being able to videotape it and play it in the opening, it really allows you to take control of the first impression of that witness or that party that the jury has.
Without a doubt, it really does. And, the same thing. So when you have, you're in trial, you've got a defendant doctor on the stand. He's testified in direct, or you're calling him in your case, and the answers are different from the deposition. Well, instead of just the old way of, okay, let me show you your deposition, turn to page 62, line 8, read the question. Now, what was your answer? Instead of doing that, you play the video clip, and there they are on the stand, and you have their video on the screen that shows the answer they previously gave. I think it's really, really effective. And again, the thinking used to be a number of years ago, well, videotape the defendant doctor in a med mal case for sure. Now, look, if it's a deposition that's worth taking, it's a deposition that's worth videotaping.
Is it more county by county or even judge by judge whether they'll allow the use of video clips in openings?
I can tell you, you're not going to do it in Schuylkill County and a lot of the surrounding counties. So it is county by county, and I would say within counties, it's judge by judge. You need to do your homework ahead of time and ask, in advance, so you don't just show up. And I think you really need to do that. Don't expect that you're going to be able to play video clips in an opening, especially if you're in front of an unfamiliar judge in an unfamiliar county. Do your homework. Either check with the judge's law clerk or talk to colleagues that practice in front of that judge in that county.
I think one of the best arguments I've always seen for that, in arguing for being able to use videotape deposition clips in an opening statement, is, Your Honor, I'm allowed to characterize what the witness said. I can read the transcript with my own inflection, what the witness said or how they said it, what's going to be most accurate, whether I do those things or if I just let the video speak for itself and let the jury see exactly what the witness said and how they said it.
Well, exactly. And, we're always taught as young lawyers trying our first trial or our first few trials that if the judge says you're argumentative, then just say the evidence will show. And the argument going forward is, Judge, the evidence will show, and I'm going to show the evidence that we will show. So, I think you can make that. Now, I know certain judges that will remain nameless, that it doesn't matter what creative argument you come up with, they're going to say you're not showing any video clips and you're not holding up any exhibits. That's it. So again, you have to know where you are and who you're in front of. But it still goes back to, what is the downside of videotaping all of your depositions that you're going to take, especially the critical ones? There's no downside to it. Yes, there's a cost associated with it, but look, when you're heading to trial, you want to focus on giving your client every possible advantage and the best presentation you can give them. If it's a smaller case, it's going to be an arbitration level case, and you know that from day one, all right, well, maybe you're not going to videotape the depositions. But in this new day and age where the thinking on depositions is you don't need to go into 7 minutes of instruction and 35 minutes of the background of the witness, go right for the jugular or cut to the chase, it just makes it that much more effective to video depositions, I think.
Certainly. All right, Sud. Well, I know you have other issues to attend to. Anything else? Any parting words of wisdom? I know we covered a lot of ground here. Really appreciate your time.
No, that's it. Again, I want to thank you, Paul, for being a business partner of PAJ for a long time. It's been a great partnership and a great relationship. But I can say, having worked with you and Jamie and others from your firm, you do a fantastic job. And, everyone always wants to say, well, I got this verdict or I got that verdict, but really there's a whole lot more that goes into success in the courtroom. And you've been a big part of that, not only for my firm, but for many of the other PAJ and other firms that you work with. And I just would be very remiss in not giving Precise a plug and you personally for the great work you do. You're a big part of our success, and we really appreciate it.
I appreciate that, Sid, greatly. All right. Well, thanks again for your time, Sid. If there's any questions, I'll be able to provide any follow-up responses to you. And yeah, have a wonderful day and enjoy the rest of your presidential term.
Great. Thanks so much, Paul. Appreciate it.
Have a great day.
All right. So long.